Good morning. You're Lamone Yeoman Jr. And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or ready to go?
No, Your Honor.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the I believe you pled true, not true, number 7, which is felony. I do want to address that.
Okay.
So I meant that on number 6, the firearm case, nothing's been brought over, nothing's been filed, so I didn't just put it on that here.
Okay. Hold on. You may proceed.
Would you please?
I'm sorry. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And how long? And during your time of probation, you supervised Junior?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th, not see him since. So, is it fair to say, it's safe to say, on April 11th, 2025, April 1st, 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report.
Stop right there. This is already serious. He's on probation for aggravated assault with a deadly weapon. That's a second-degree felony and burglary. And he's already pled true to violations in the motion to revoke. In probation court, true is basically the fast track to sentencing. The judge doesn't need a full trial. One proven violation is enough. So this hearing, it's not about guilt anymore. It's about how much time
Required to see you or permission. Thank you. I'll pass witness.
Any questions?
Also, can you give me that date that he did report? And Deb, you were talking about
I called him actually on his birthday, and I told him that he told me because it was his birthday.
was there? Were you aware of any time while he's since his removal from proceeding? Were you aware of any time you may have called him or sent him text messages about a data report that he didn't get?
I called, I sent letters, and I called him. And his mother told me that he was aware of the persecutions.
I pass witness. Another question for purposes of improvement. Count number 7, Your Honor.
Okay. Based on any witnesses or information about count number 7.
Okay.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report as well as there was a letter provided this. Mr. Nichols, have you had an opportunity to review the letter? It's from. You can take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, yes, Your Honor.
Any additions or corrections to that report?
Just a correction. Page 1, the bottom paragraph, it says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of it.
Okay. I guess being kicked out is better than being absconded. Anyway, all right. Anything else?
This is the PSI number.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading this.
time he's about to get. Failure to report confirmed. Warrant issued. Mom knew about it. He knew about it. Here's what people don't realize. Probation isn't optional attendance. Reporting is the bare minimum. when you disappear. Courts call that absconding. And judges take that personally because it looks like you're dodging supervision. So now we've got multiple violations stacking up. The pressure just went way. This right here is the only thing saving him from potentially worse. There's a cap of 8 years on the aggravated assault case. Without that cap, he could be looking at a much higher range under Texas law. But notice the strategy. Open on the burglary, capped on the assault. That's a gamble. And when a defendant keeps coming back on revocations,
Mr. Yeoman was in safety. He did successfully finish the first part of safety. The aftercare program is a part that he was kicked out of. He pled not to count one as far as that counts since he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2, so everybody in that room was kicked out. And that really just started the downfall on probation. At that point, he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the message will get to the report, he wasn't able to know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, as far as the possession and the weapon charge. So according to, if his story is to be believed, that he was not selling K2 and everybody got kicked out.
There's not much for you to argue here today. You haven't given your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he probably would still have been able to finish that safety program, and that's what he's asking to get the opportunity to do this morning. Finish that aftercare program, possibly even do the new offense, maybe even consider sending to ISF Cognitive to help them make better decisions. And if you had more questions about what happened to safety, Mr. Young will talk about this.
So there was an ISF. There have been 7 administrative hearings. 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally at what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case. While you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony.
Judges start running out of patience. At this point, do you think the court is thinking rehabilitation or exhaustion? That line hits hard. When a judge says there's nothing left to argue, that usually means credibility is gone. Multiple revocations, multiple chances, administrative hearings, jail sanctions, safe, aftercare, new arrests. Probation only works if someone participates. And here's the bigger issue. When excuses start piling up, judges start seeing patterns instead of circumstances. How many chances is too many?
Give you another probation for the second. And then we're here again. I sent you to safety. And not only did you get kicked out of safety, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the folks in the camp that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of last year. That he's been given multiple chances. And if you go back to his original PSI in 2019 office, I guess he downplays what he did. And he's never taken responsibility, really, for what he does. And I think the recommendations of the probation are correct, and that he just refuses to grow up, refuses to take responsibility for his actions. So I think 8 years.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's going to keep giving me probation. I'm going to come in, I'm going to write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 1932846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23, DCCR 1556. Also find counts 1, 2, 4, 5 that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rhodes. You can go back with the brief. Thank you.